If you are an immigrant parent and your child was born in the United States, you have probably seen the scary headlines. Birthright citizenship could be ending, the Supreme Court is involved, and families on temporary visas are being told their US-born child might not be a citizen anymore. Size. Here is the calm, practical goal of this video. By the end, you will understand 3 things. 1. What can realistically change and what cannot change overnight. 2. Which families are most likely to face confusion or delays in the real world, even before any final ruling. And 3. A step-by-step plan to protect your child's paperwork, travel, and access to basic services while the legal fight plays out. And here is the micro-hook that matters. In these situations, the biggest risk is not always a sudden change in the Constitution. The biggest risk is messy implementation. A passport appointment, an SSN application, a school enrollment, an airline check-in, or a benefits renewal where a frontline worker does not know the rules, and your family is the one stuck proving what should already be obvious. Now, before we go any further, we need to separate what we can verify from what we cannot yet confirm. Your brief says there is an Executive Order 16160, signed January 20th, 2025, described as designed to end birthright citizenship for children born in the U.S. to certain immigrant parents. It also says the order has not gone into effect due to federal court injunctions. And it says the Supreme Court hears oral arguments April 1st, 2026 in a case described as Trump versus Barbara, with a final ruling expected in summer 2026. I am not going to add details beyond what you provided. I am also not going to assume what the Supreme Court will do. What I can do is explain how these cases typically work, what families should watch for, and what actions are safe and helpful, no matter what the outcome is. Here is the part most people miss. Even when something is blocked by an injunction, the information ecosystem moves faster than the law. Employers, schools, clinics, and even travel staff can react to rumors. So your plan has to cover both law and day-to-day proof. Let's talk about what an executive order is and what it is not. An executive order is an instruction from the president to the executive branch. It can guide how agencies interpret and enforce laws within the bounds of existing statutes and the Constitution. But an executive order cannot, by itself, rewrite the Constitution. It also cannot erase Supreme Court precedent by declaration. So when people hear an executive order and think, "My child is no longer a citizen tomorrow," that is usually not how it works. But executive orders can still matter. They can trigger agency policy changes, legal challenges, and confusion about procedures. And if courts ultimately allow a narrower interpretation of citizenship, or the government's ability to define who is subject to jurisdiction, agencies could try to update guidance on documents and adjudications. That is why this is a high-stakes topic even for families who believe the law is on their side. Now let's define the key phrase that shows up in almost every birthright citizenship conversation: the 14th Amendment. The commonly cited core idea is, if you are born in the United States and subject to the jurisdiction of the United States, you are a citizen. The other name you heard in your brief is United States versus Wong Kim Ark, a Supreme Court case often discussed as a major precedent supporting birthright citizenship for children born in the US. This is where people tend to get overconfident or underconfident. Myth versus reality number 1. Myth: a US birth certificate is the only thing you will ever need, and nobody can ever question anything. Reality: a US birth certificate is powerful evidence of birth in the United States. But in real life, different agencies and systems use different rules for verification. Sometimes they ask for a passport. Sometimes they ask for an SSN. Sometimes they run database checks. You can be right and still be delayed. Myth versus reality number 2. Myth: if a case is at the Supreme Court, your child's citizenship is already gone. Reality: A case being heard means the legal question is under review, until a final decision changes the controlling rules and agencies implement it. Your child's status and your practical documentation path usually stays under the current framework, especially if there are active injunctions, as your brief states. Now let's get specific about who is most likely to be anxious and who is most likely to face practical problems first. Based on your brief, the groups being discussed include parents in the U.S. on temporary statuses like H-1B, F-1, H-4, J-1, L-1, B-2 tourist status, or the Visa Waiver Program. If you are in one of these categories and your child is U.S. born, here is what to understand. Your child's citizenship question, as discussed in public debate, is not usually about whether the child was born in the U.S. It is about the interpretation of that constitutional phrase subject to the jurisdiction. The reason this matters is that some arguments attempt to draw lines between people who are fully under U.S. jurisdiction and those who are allegedly not, based on the parent's status. I am not endorsing that argument. I am explaining why temporary visa families are getting pulled into this. Now, who is not usually the center of these claims? In general terms, children born outside the U.S. are not claiming birthright citizenship based on U.S. soil because they were not born on U.S. soil. That is a different process. Also, families with existing proof structures already completed, like a U.S. passport already issued for the child, often feel more secure. But here is the catch. Even a passport does not remove all future uncertainty if rules and procedures change later. It is strong evidence, and it helps in the real world, but it does not stop a future policy fight from creating new documentation steps. Here's the small detail that changes everything. The highest risk moment is when you are applying for something new for the child, not when you are just living day to day. Let's walk through real-world consequences that families should take seriously, because these are the places where confusion can hurt you even before any final ruling. First, passport processing. If you need to apply for your child's first U.S. passport, renew a passport, or get an emergency passport for travel, a policy shock or rumor cycle can cause processing delays. Even if nothing has legally changed, you can see longer appointment waits, extra scrutiny, or requests for additional evidence. This is especially likely during high-demand periods like summer. Second, Social Security number applications for newborns. Many families apply at the hospital or soon after. If there is any mismatch in names, dates, or documents, the case can already be delayed. Add a politicized public debate and you can see more questions, more referrals, or more back and forth even when the child is eligible. Third, benefits and insurance systems. Your brief mentions programs like Medicaid, CHIP, and SNAP. I cannot confirm any specific outcomes without an official policy change, but here is the practical point. Eligibility systems often rely on citizenship verification. If a worker is confused, you may have to provide proof again, or you may face a temporary denial that you then appeal or correct. Fourth, travel. For U.S. citizen children traveling with non-citizen parents, international trips already come with extra friction. Consent letters, custody paperwork in some situations, and carrying birth certificates to prove parent-child relationship. In a high-noise environment, the number one mistake is traveling with minimal documents and assuming everything will be fine. Here is an example scenario, a composite of situations families report. Example scenario: you are a parent on an H-1B or F-1. Your baby was born in the U.S. You booked an international trip to visit family. You arrive at the airline counter with the baby's foreign passport because a relative told you it is easier, and you do not bring the U.S. birth certificate. The agent asks why the child does not have a U.S. passport if the child was born in the U.S. Now you are stuck explaining citizenship, jurisdiction, and court injunctions to a person who has a checklist and a supervisor. This is where people miss flights. not because the child is not a citizen, but because the family did not bring the documents that make the situation simple. So what should you do now, before summer 2026, while the case is pending and the information environment is noisy? I am going to give you a practical 6-step plan focused on documentation and risk reduction. This is not legal advice. It is a common-sense preparedness plan. Step 1. Secure the child's long-form birth certificate. Do this. Order more than one certified copy and store one safely at home and one in a secure backup location. Avoid this, relying on a photocopy only, or assuming the hospital souvenir certificate is the official one. Step 2. Get and organize proof of parent-child relationship and identity. Do this. Keep copies of the parents' passports, visas, I-94 records if applicable, and the child's birth certificate together in one folder. Avoid this, scrambling across email, old suitcases, and multiple phones when an agency asks a question. Step 3. Consider obtaining a U.S. passport for the child if eligible, and if it fits your plans. Do this. Look up current official passport application requirements and book appointments early. Avoid this, waiting until 2 weeks before travel, especially in peak seasons. Step 4. Check the child's social security number status and fix errors early. Do this. Confirm the name spelling, date of birth, and consistency across records. Avoid this, letting a small mismatch sit for years, because it becomes a bigger headache when you need benefits, taxes, school enrollment, or travel. Step 5. Build a travel packet for any trip. Do this. Travel with the child's U.S. birth certificate, U.S. passport if issued, and supporting documents that show parentage and consent if applicable. Avoid this. Traveling with only one document and assuming the airline or border systems will figure it out. Step 6. Monitor official sources and save screenshots of key updates. Do this. Follow the Supreme Court docket through reputable case trackers and watch for agency guidance updates from official government websites. Avoid this, making big life decisions based on viral clips, anonymous posts, or unverified claims. Here's another micro hook. If there is one thing to do today that helps in almost every scenario, it is making your documentation boring. Boring paperwork gets processed faster. Drama paperwork gets delayed. Now let's do a quick myth versus reality that will reduce panic. Myth. If the Supreme Court rules a certain way, every US-born child of non-citizen parents immediately loses citizenship. Reality. Even major Supreme Court decisions typically require interpretation, implementation guidance, and often generate additional litigation about how to apply the decision. There can be transition questions, effective dates, and procedural steps. The most immediate effect for many families is confusion and delays, not instant mass changes. Myth. If your child is a citizen, you never need to worry about documents again. Reality. Citizenship is one question, proof is another. For travel, school, benefits, and identity verification, the question becomes, can you prove it quickly, consistently, and in the format the system accepts? Now I want to give you the calm script you can use if someone questions your child's citizenship in a real-world setting. Use this as a starting point and keep it simple. Say, my child was born in the United States. Under the 14th Amendment, my child is a United States citizen. Here is the certified U.S. birth certificate. If there are any policy changes being discussed, my understanding is that current rules remain in place while the courts and official guidance control implementation. Notice what that does. It avoids arguing politics. It avoids threats. It anchors to basic facts. Born in the U.S., here is proof, and current procedures matter. If the person is an airline agent or a school administrator, your goal is not to win a constitutional debate. Your goal is to move the interaction to a supervisor or to the correct checklist. Now, what could happen next as we approach summer 2026 based on the kind of timeline your brief describes? There are a few watch points. Watch point 1, the Supreme Court decision itself. A ruling can be narrow or broad. It can focus on procedure, standing, injunction scope, or the underlying constitutional question. Until you see the actual decision and reputable analysis, treat hot takes as speculation. Watch point 2, injunctions and how far they reach. Your brief says the order has never gone into effect due to federal court injunctions, and it references an injunction that currently protects families. If injunctions are modified, narrowed, or lifted, that is when agencies may attempt changes faster. Watch point 3, agency guidance. Even without new legislation, agencies can publish updated instructions for adjudicators and frontline staff. That could affect how passport evidence is evaluated, how SSN cases are processed, or how benefit eligibility is verified. Watch point 4, demand surges. If families rush for passports, birth certificates, and SSNs at the same time, the system clogs. The earlier you prepare, the less you are exposed to peak season delays. Here is the part most people miss. Whatever your views are about this debate, the safest strategy is to reduce your dependency on last-minute processing. If you anticipate travel, plan earlier. If you need documents, order them earlier. If you see an error, correct it earlier. One more example scenario to make this real. Example scenario. Your child is 2 years old. You never applied for a passport. Summer 2026 approaches, and relatives abroad have an emergency. You now need an expedited passport appointment during peak season, while the news is full of Supreme Court coverage. Even if nothing has changed for your child legally, you are now competing with a surge of applicants and extra scrutiny. Your stress level is not caused by the Constitution. It is caused by timing. So let's close with a clear recap, and then I will leave you with one calm next step. Recap in 5 points. 1. An executive order can trigger policy moves and litigation, but it does not automatically rewrite the Constitution by itself. 2. While court injunctions are in place, families should focus on current procedures and strong proof, not panic. 3. The real-world risk is confusion and delays in passports, SSNs, benefits verification, and travel check-ins. 4. Temporary visa families are the ones most likely to face questions first, because that is where the public debate is focused. 5. Your best protection is a boring, complete document folder plus early planning before peak seasons. If you want one action to take today, make a single family folder, physical or digital, with certified birth certificate copies, parent IDs, and any child documents. And then set a reminder to check official updates on a fixed schedule, like once a week, not every hour, free. If you found this useful, consider subscribing and turning on notifications, because when major rulings or guidance changes drop, the most helpful content is the calm walkthrough that tells you who is affected, what to do, and what to ignore.